Oh, sorry, ek het nie. Okay, en ons is live.
En ons is live. So ja, kom ons wag nou net vir ons mensies.
Nee, dit was mense se stelmenskat hoor. Ek dink jy kan maar skiet.
Okay, nee maar okay. Laat ek net die eerste enetjie sien at least. Kom ons wag net 'n bietjie. Daar's hy. There we go. Okay, hi julle. So, ek begin in Afrikaans, maar ons gaan aangaan in Engels. Wat ons vanaand oor gaan praat. Hoe ironies dit is. Dat hoe mense gate vir hulle self grou, maar self daarin gaan val. En dit is nou veral die employers wat so verkeerde inligting kry en dit nogals deur hulle prokureurs en hulle legal panels. Laat Schalk julle meer vertel.
Dankie Leonie. Ja, ons sit met ons eerste wat was die spesifieke frase? Let me continue in English. We're sitting with our first permanently incapacitated workers.
Who's not in yeah. There's
Yeah,
nothing
in
wrong with them,
terms-
so
Yeah, please forgive me. I just couldn't help but laughing. Okay, we're sitting with our first permanently incapacitated employees. In terms of the outcomes of the CCMA, you'll remember the Mulderij case, where a commissioner found a wholly healthy person, and it was common cause, to be permanently incapacitated. But we're sitting with our first follow-ups after that of where people, employers, went to their attorneys and advocates, and that very next morning, Patsy, I'm vra vandag my bankbesonderhede. And where those people went literally the next morning and started threatening and coercing their employees because all of a sudden now they have been validated, or they thought that they were being validated by the CCMA in their wrongdoing. And we have had our first dismissals. Dismissals based on incapacity. Now let's rewind a little bit, and I like to do that with my hands. And the famous wiggle of the nose. If we go back and scroll down my video list, we will find videos in which I specifically informed employers, you must go to section 192.2 of the Labour Relations Act, and you must read that with Schedule 8 to the Labour Relations Act. Because in that you find mechanisms through which you can lawfully, legally, within the bounds of law, dismiss an employee. If you go outside those bounds, then you are dismissing the employee unfairly. You will find it. You cannot dismiss an employee that is unvaxxed for incapacity. You simply cannot do that. The law does not provide for it. Okay? Now, unfortunately, this commissioner, because he most probably never in his life presided over any of these processes that he's trying to now adjudicate on, in his wisdom, he went and he found a wholly, totally healthy person permanently incapacitated because she did not vaccinate by choice. And a few employers followed suit to start dismissing employees for incapacity. And those employees started calling me as from last week, about Wednesday. I think I got my first case around Wednesday, where they came to the Department of Labour with their UIF 19 claims form, completed and signed off by the CEO of the company to say that they can go and claim their benefits now from UIF, only to be told by the Department of Labour, but if you are incapacitated, as your employer alleges, then obviously you must have a doctor's certificate, a medical certificate of at least one doctor, but preferably two, who declares you unfit for duties. So in other words, you can't work anymore. Otherwise, obviously, you can't get your benefits from UIF. Now, this is not the problem of the employee. Remember, the agreement or the legal nexus in this instance is between employer and UIF. Not the employee. The employee is a third party, only there to go and collect his benefits. And the Department of Labour then started calling up the employers to ask of them, but Mr. Employer, you said the employee is now permanently incapacitated. It stands here on the form in front of me. Reason for termination, incapacity. But he says there's no doctor certificate. Can you please provide that to us? And obviously, the employer could not provide such document. Mr. Employer, listening to this, please go and read the legislation around the Unemployment Insurance Fund, the UIF. There's actual legislation. It's not just something you just pay money into and hope for the best. There's legislation creating the fund, administering the fund, and setting the rules in terms of which employees can get their benefits. And if an employee is found to be incapacitated from duty, hy is nou ongeskik vir diens, it means that there must at least be a doctor certificate, and he must have been found incapacitated in the workplace due to illness or injury by a medical professional. Otherwise, the worker cannot get his benefits. But here's the problem for you, Mr. Employer. If you do something that is not correct, you create a misinterpretation or misrepresentation to the UIF, that is deemed to be fraud, criminal fraud, for which in terms of the UIF Act, the legislation, you can actually either get a very, very steep fine, or you can actually go to prison. Were you aware of this? When your consultant or your attorney phoned you that evening after my video about the finding of the CCMA, because he heard it here on my video, he didn't read it in the media heard it on my video, and he phoned you, and he was all smiles and all starry-eyed, because he found a solution now of getting rid of your problem employee, and that is through incapacity, because some commissioner somewhere did say that in an award. Did he also tell you that if you write that down on a UIF form and it's not the truth, you're committing fraud for which you can go to prison? Mm-hmm. I guess not. I spoke to the employees involved. I have 3 cases by now. I spoke to all 3 the employees, and I'm urging them to go and lay criminal charges of fraud against the employer. I also spoke to the Department of Labour. They are still a little wishy-washy on the whole issue, informing them that if an employer misrepresents, they have a duty, not a discretion, a duty, to then charge that employer with fraud. It also goes for retrenchment. If you retrench an employee but you did not follow section 189, it is called a feint retrenchment. Especially if you retrench only one person at a time. Net, dit word genoem 'n vals aflegging. Because you're trying to bamboozle the UIF into thinking that worker must get his benefits. It's fraud. But nobody told you that, did they?
Maybe they did.
So all the employers, Standard Bank, Sanlam, Mediclinic.
Especially Mediclinic.
Yeah.
They don't want to listen.
Mediclinic. Listen to Schalk now and listen to me good. It's not me saying this. This is what law says. Law says you cannot find a person that is totally healthy to be permanently incapacitated because your consultant says so. Right? You cannot do it. It's fraud. And the worker will not be able to go and collect his benefits because there's going to be a dispute. Okay? And you are going to end up being charged. Not the employee. He doesn't fill in the UIF form and signs it off. Go and read the wording of the document UIF 19 that you sign off. The lady brings it to your office. You don't even know what's written there because the bookkeeper filled in all the little numbers and dates. You only sign it off. Take that form tomorrow morning. go and read what you sign off. You sign off that document as true and correct. And the implication of that is that if it's not true and correct, you, Mr. CEO, or you, Mr. Financial Director, or whoever, signing off the UIF 19 form, becomes liable to be charged criminally in terms of the UIF Act. But you didn't know that because it was not told to you. Okay? That's the first aspect. The second aspect. Today only, just before I went onto video, I did my 78th client for the day.
I can confirm that.
Right? And it was a quiet day. Sometimes I sit until past 12 in the evenings still working with clients. Right? Those clients mostly now have to apply for exemption. And up to now, there were usually 3 grounds for this. Religion. Now we know Commissioner Peter Venter, he said Christians can't get exemption, so by implication Muslims can't get it, and Buddhists can't get it, and pagans can't get it, because Peter Venter said so.
No religion.
Right? So forget about religion. Secondly, medical, and that is only where you have a very strange related illness to vaccine that has now been established by science, what, and your specialist even wrote that in a letter. So that's as difficult as a camel passing through the eye of a needle. But thirdly, on constitutional grounds. Now my 850 clients, those notorious 850 rand clients, receiving my documents will know exactly what I'm speaking about now. They get a bundle of documents. In that bundle, 2 opinions, 2 legal opinions, and then a host of legislation, amongst others, the Constitution. One of the opinions deal with ancillary laws, in other words, Labour Relations Act, Employment Equity Act, NCID rules, etc., etc. It just touches on the Constitution, because the point that we are bringing across is, Mr. Employer, just take note, we're not only speaking of the Constitution, we're also speaking of other legislation in South Africa, making it impossible, if not illegal, for you to dismiss employees. But the second one deals specifically with constitutional issues. And not only Section 12, we deal with most of the Constitution, even beyond Chapter 2, being the Bill of Rights. Right? If you throw that at an employer, you stop them in their 4 tracks. You stop them dull-eyed. I've had employees calling me saying to me, I've never seen the expression on a person's face like the one I saw on my boss's face today when he started reading through those documents. There's a reason why. I sent the opinions, which comes from my mind, very well studied, very well prepared, but then the actual legislation that I refer to in my opinion is attached, so that the employer can read the opinion and then cross-reference it back into the law itself. And then he realizes, oh gosh.
It's not just Schalk, it's the law.
It's the law. It's the black letter law of the Republic of South Africa as enacted by Parliament. But you can't go around the law. Because if you go around the law, you end up like these silly employers who's now going to be charged for fraud because they're trying to screw the UIF fund, not even knowing what they are doing. Okay, and now something very strange happened. As of today, many of the exemption applications,
which is a load of bull, by the way,
has deleted option 3, constitutional aspects. Most now only include religion and medical. I think because they know what has been put in front of them now, by this time, I would assume it must be thousands of workers. I don't know how many exemptions I've done.
So many. Too many.
The same message over again, because you copy and pasted a policy, therefore I can copy and paste my response to the policy.
Oh, you can't trust the government. Just saying.
You can't trust the government. You can't trust politicians either. Left wing, right wing, same bird. Nee, it's that concept, but people also don't click that. But the long and the short is, I think that employers and their representatives and their advocates and their attorneys started realizing, oh shit, pardon my French, ladies. Schalk's response to the copy and paste policy that I gave you cannot be overcome in law. It just simply can't. And that is why they are now backtracking and deleting. They actually delete the option of constitutional grounds as an exemption to vaccination. We have one of the biggest attorneys firms in South Africa. I'm not going to call their name as yet because they have not screwed up so much. They're actually quite responsible on what they are doing, but they must now do the same because they already told it to their clients. They made the app on which you can go and read read the policy, the vaccination policy, so that you cannot download it now. So you can take photographs with your camera, which people have actually done to send it to me, but you can't download the document anymore. I must call the name. Cliff Decker. Can you believe it? Your workers can't download the policy that you drafted. They're laughing at you guys. They are actually laughing. They call me up. They say to me, Schalk, I wanted to send the new policy to you, but I can't even download it. Are you serious? But yes, I guess in future you're not going to have the option anymore of constitutional grounds as a ground for so-called exemption from a policy that's clearly against the law. How obscene and strange and contradictory that may be. Okay, Mr. Employer, we're not going to back down, unfortunately. So you can take it out of your policy, and you can take it out of your exemption application and the options on your exemption application. My advice to every one of my clients, my members, are exactly the same. Draft this into an email, attach the annexes, the legislation, and still send it onto your HR. And in your letter, you write to them nicely. Don't pick a fight. Nicely. Just write to them. Gents, are you aware of all these legislation that's applicable in this case of mandatory vaccination? We're not going to stop. Because now you have been pre-warned on the issue. You have the actual legislation in your hands. So by the time we go and turn in labor court, in labor appeals court, you cannot say that you were not aware of this. And that is what we are doing at this point.
Sorry, fire employees. Just read that quick. Sorry, and now it's gone. But someone was asking about fire employees.
What is fire? Fire means dismissal. It's a slang for dismissal.
I can't go back now.
No, it's fine. We can have a look at it later. So people, it was a short video. I'm not going to speak a lot any further. I'm really tired out. I'm going to sleep early tonight. But it was a very interesting weekend and a very interesting 2 or 3 days around this weekend.
I think just once again, please just explain to the people about the change in the Gazette, because people are still asking about it. So it's still something new. So yes, please explain.
It's a subject on its own. In short, a person that is asymptomatic, in other words, they do not show symptoms, although they have COVID, can roam freely, move everywhere and anywhere without any obstruction. But if you are symptomatic and found to be symptomatic after a laboratory test, then there are so many restrictions on you, to the extent that you can even be incarcerated for more than 48 hours, for maximum of 48 hours, and brought before a magistrate's court, who can then extend your incarceration until such time as deemed fit by the court. Simply meaning that theoretically, if they think that you are ill, they can send you to a doctor, and the doctor can test you through a laboratory test. And if you found to have COVID, they can incarcerate you as long as they want. That's actually what this legislation, the door that is being opened. Whether it's going to be enforced so harshly, we need to see that. But the law has been set. Not the law, sorry. sorry, my mistake, I'm really tired. The grounds has been set now for what can become the most draconic measures we've ever seen in South Africa. If you think apartheid was bad, you do not have the faintest idea of what these guys are busy with, right? And it's already now in those regulations. Remember, regulation is not law. It's not an enactment of Parliament. It was never before Parliament for scrutiny. It was never voted on. It was never open to public participation. So it's not law, but it is a regulation. And we certainly need to keep our eyes on that, and we need to fight it. But yes, that's in short what is the regulation. Maybe I must do a whole video only on the subject of this.
And the emphasis on fighting it. We need to fight it.
Yes. So let's agree to disagree. No, let's agree to agree that tomorrow evening, about this time, Leonie and I will make a video specifically about these regulations, and also what Jared spoke about in certain parts of the new legislation relating to the medical profession and medicine and all these things. I will just touch up with Jared. It's Jared Petzer that I'm speaking about. I'll just touch up tomorrow with him, so that I can also present that to you.
Okay. Well, any case, like I said, we will look at the comments and try to answer some of them, because like the last one, it was more than 700 comments. I mean, seriously, it's a lot. We can't get to all of them. But I've seen a lot of people who asked that we contact them. I will have a look at the comments, and yeah, I will try to come back to most of you.
Ja, ouens, julle moet onthou, it's happening what I predicted. The dam walls have broken. I cannot tell you how many people are sitting out there facing possible dismissal within the bounds of this week alone.
So many people.
Not mentioning until February, not mentioning the next 2 months. It's heartbreaking to experience, and it's shocking to see what is exactly happening out there. Yes, the dam walls have opened, and that is why we are working as fast as we can. That is why I'm saying, just think for yourself now, 78 clients, and I don't know how many came in now. 78 clients just for today, not mentioning that we had to attend court this morning. We were there, then we started to work, then we had a very short lunch, and you will see maybe a little video from Leonie. Something a little bit romantic, because it is after all 14th of February.
Yeah, Valentine's Day, we worked it in our work schedule, but just like a short while.
The 5 minutes we could.
Yes.
But the rest of the day, unfortunately, it was taken up in its totality by work. So we trying as many as possible. As I already said, also we're now starting to throw out work to trusted attorneys firms and trade unions, because we simply cannot do the CCMA and those things also. There's quite a number of CCMA cases already coming up in February. Some of them I will handle personally, but some of them I will give over to our strategic partners. I think let's cut, my dear.
Yeah, no, I'm reading the comments while I'm trying to, but yeah, I'll try and have a look at it and answer most of them. Or well, I'll try. Yeah, because we have emails and everything, so it's just so much.
we will definitely come back online tomorrow evening. We will definitely do that. Maybe we should do two videos. There we're gone and we're back again.
Yeah. So please don't stress.
It's only policy.
You don't have to take the vaccine, okay? You don't have to.
Yes, and please don't resign.
Please don't resign. Yes, please don't. Because then you don't have a case.
But you can't claim UIF in any event.
There we go. Okay.
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 Het jy 'n houtlepel nodig? Nee, ek het 'n bietjie meer. Ek maak eens lus om 'n slag iemand te bliksem, hoor. Like in the olden days, huh?
Oh my goodness.
But yeah, let's step off. We will definitely be back tomorrow. No, I'm stepping off.
I just want to say one last thing. I've seen many compliments. Thank you so much. I just want to say thank you.
Okay. Nice evening to you. We speak again tomorrow.
Keep well.